Our speaker today is David Vitale, who's an associate professor of public law and I think in some aspects of constitutional theory at Warwick University, who is a long-term attender of public law events at UCL Laws, and always we're grateful to have you here for your expertise. And he'll be presenting his book for about 25 minutes for the beginning of this session. And then we'll hear from two esteemed commentators who are also working on the topic of social rights. Professor Virginia Mantouvalou, who is a professor of human rights and labor law here at UCL and has worked on this topic for a very long time as well. And Colm, who has worked on this topic academically for decades and was also vice president to the European Committee on Social Rights, which supervises compliance with social charter. So we're very lucky to have a lot of expertise in the room. And I'd just say, by way of introduction, David, that the book exemplifies the kind of scholarship we like to have here. It's dealing with doctrinal questions in sociology and empirical and constitutional theory. And so it's lovely to host you here.
Thank you for being here. Yeah, okay. Let me start by, well, it's a great turnout. Thank you all for coming along. And let me start, of course, by thanking Aaron and Jeff for their kind invitation to let me talk about my book. And of course, to Colm and Virginia for, I'm sure will be an interesting discussion. So the book responds to a relatively long-standing and contentious debate in the comparative constitutional law literature. And that debate concerns how courts globally can and should go about enforcing social rights that are protected under national constitutions. Now, just to provide some context, in the last 30 years or so, we've seen a global rise in both constitutionalized and justiciable social rights. Empirical research by Rand Herschel and others has shown that more than 90% of constitutions globally contain at least one express and justiciable social or economic rights provision. And where social rights are not expressly protected in constitutions, so here I'm thinking of jurisdictions like Germany, Israel, and India, it's become commonplace for courts to read social rights into general constitutional provisions. So things like the right to life or the right to human dignity. And in tandem with this increased constitutionalization of social rights, there's simultaneously been a proliferation, or some have called it an explosion, in social rights litigation. But despite this kind of global trend towards increased, shall we say, protection of social rights at the constitutional level, there's still been significant disagreement among scholars, judges, and others regarding how exactly courts should enforce this controversial category of rights. And so that's what where my book comes in. I basically propose a new legal framework for the judicial enforcement of social rights. And that framework is rooted in the concept of trust, more specifically, the concept of public trust in government, or what I refer to in the book as political trust. And in a nutshell, and I'll go into more detail in a few minutes, but under this trust-based framework, what courts do is they enforce social rights by promoting the trustworthiness of government actors, specifically with respect to social rights related goods and services. Thereby, what they do is they effectively, what I call, create the conditions under which the public can or is able to trust its government in this particular area of social rights. And so today, in talking about kind of the book and the framework, what I want to do is address 4 questions that are covered in the book. I'm going to start with kind of a necessary preliminary question, and that's the question of why we should be interested in the concept of trust at all. Why look at this area of social rights law from the perspective of trust? And so this, I hope, will set the stage for kind of my discussion of trust, and will justify why I think we should all be interested in the concept of trust with respect to social rights and more broadly with respect to law. Then second, if we accept that trust is relevant to social rights law, which I hope I'll convince you at least a bit. The question that is raised is, well, what does it mean then for the public to trust its government with respect to social rights? So that'll be a question of conceptualization. Third, having established, hopefully, trust's relevance and meaning, the third question I want to address is, well, why then should we base a social rights enforcement framework on this concept of trust? And so this question goes beyond kind of the mere relevance of trust to social rights law, and more precisely, it asks for the normative justification for a trust-based social rights enforcement framework. And then lastly, and perhaps most pragmatically, the question is, well, what does a trust-based social rights enforcement framework look like? What does it involve? So I want to kind of just go through a bit of a snapshot of what the framework that I'm proposing involves. So I'll start with the first question. So why examine social rights from the perspective of trust? Now, trust has received a lot of attention recently, both in academic work as well as in kind of broader political commentary, the media. We kind of, to some extent, see the word trust thrown around everywhere. And a significant reason for this widespread attention is the value that trust is said to have for our relationships. So in particular, it's for quite some time been argued and in fact empirically demonstrated that what trust does is it promotes cooperation, and that cooperation facilitates our transactions with one another. So here I'm thinking of the work, for example, of psychologist Tom Tyler, as well as just as another example, political scientist Russell Dalton. And so in the political context, this means that public trust in government, what it does is it promotes, perhaps obviously, public cooperation with government. So the more we trust our government, the more likely we are to cooperate with government. Now, in what I consider to be of particular relevance to social rights and social rights law, this public cooperation with government manifests itself in two, shall we say, significant forms. First, it manifests itself as the public's willingness to pay taxes. So research has shown that the more the public trusts its government, the more willing it is to pay taxes. And this includes accurately reporting income and not overstating tax deductions. And second, this public cooperation with government manifests itself in the public's, shall we say, overall support for government policy. So here the idea is that the more the public trusts its government, the more likely it is to grant government what political scientist Margaret Levi has termed, quote unquote, contingent consent. And so what they do is they support or they tolerate the government's policies, even if the likely outcome of those policies is perceived to be personally, shall we say, unfavorable to the individual in question. And so both these manifestations of cooperation, they have implications for the state's ability to provide the public with the very goods and services that are the focus of social rights. So just, in briefest terms, so social rights are said to reflect constitutional entitlements to social goods and services that we need to lead a decent life, with the state having a corresponding obligation to provide the public with those goods and services. But the state's provision of those goods and services necessarily depends on resources that the public itself provides. And that includes, tax dollars or tax money, and tied with that, the public's overall support for those policies. So because of these two forms of public cooperation with government, which are required for the state to provide the goods and services that are the subject or the focus of social rights, I argue in the book that the concept of political trust is significant for social rights law. And so it's at least a worthwhile perspective from which to consider or think about social rights law. So if I've convinced you of that, that brings me to the second question, which is one of conceptualization. So what does it mean then for the public to, quote unquote, trust its government with respect to social rights? Now, based on the literature from other disciplines, as Jeff mentioned, so here I'm thinking of sociology, philosophy, but I consider other disciplines as well, we can understand trust as arising in a three-part relationship. So those three parts being a trustee, who we can call for simplistic terms, we can call A, and that's the actor being trusted. A truster, who we can call B, and that's the actor doing the trusting. And some good or service, which we can refer to as X. And that's the thing at issue in the relationship. And so it determines, shall we say, the context of the overall relationship. And so the three-part relationship takes the form of B trusts A with respect to X. So if we apply that configuration to the social rights context, and more specifically to the relationship that is at issue when we're talking about the enforcement of social rights by courts, the trustee, A, is the elected or political branches of government. And so there I'm including the legislature as well as the executive. The truster, B, is citizens. And just to be clear, by citizens, I don't mean citizenship as kind of legal status. I'm trying to kind of use a term that would capture basically those who are guaranteed social rights under the relevant constitution. And then X in the relationship are the various social goods and services that are the subject of social rights. So here we include physical goods, personnel, infrastructure, equipment, and services. So then next, again, going back to the literature on trust, we can define trust in that three-part relationship, that A-B-X relationship, as the truster, a set of, shall we say, three expectations that are held by the truster about the trustee. So those are, first, an expectation that the trustee will exercise goodwill towards the truster. Second, an expectation that the trustee will exercise competence with respect to the relevant matter or in the relevant matter. And then third, in relationships that we can characterize as fiduciary, an expectation that the trustee will fulfill their fiduciary responsibility or obligation to the truster. So again, translating back to the citizen-government relationship, for citizens to trust the elected branches with respect to social rights, it means that they expect the elected branches, when those branches make resource allocation decisions with respect to social rights related goods and services, to exercise goodwill towards them, to exercise competence, and assuming that the citizen-government relationship is fiduciary, a point that I'll get to in just a moment, to fulfill their fiduciary responsibility to citizens. So that's how we can understand trust in this citizen-government relationship, at least broadly speaking. And in a moment, I'll offer a bit more detail about what each of those kind of expectations involves. So that brings me on to my third question, and that's the one that's kind of the focus of the chapter that's been circulated for today, and that is, so why base a social rights enforcement framework on this concept of trust? And so here, what I do is I advance 4 justifications for a trust-based framework. The first justification is instrumental. Now, I said before, there is this link between trust and cooperation. And in the political context, there's this link between political trust and public cooperation with government. Following on from this trust cooperation link, I argue that through a trust-based social rights enforcement framework, like the one that I'm proposing, we can promote public cooperation with government. In particular, there's a relatively well-established line of thinking in the literature on trust. And so here I'm thinking of political scientist Russell Hardin, as well as political theorist Philip Pettit. The idea is that we can promote trust in a relationship by imposing constraints on the trustee in that relationship. So specifically, we promote trust in a relationship by imposing constraints that increase the likelihood that the trustee will fulfill the truster's trust in the trustee. By imposing these constraints, the trustee is more likely to fulfill the truster's trust in them, fostering in turn the truster's trust in the trustee. You know, there's a lot of trust. Hopefully, I can just follow. Now, if we apply this line of thinking specifically back to the social rights context, social rights adjudication by courts, I suggest in the book, should be able to foster public trust in government. More specifically, the courts, by imposing constraints on the elected branches, that increase the likelihood of them fulfilling citizens' trust in them, they should be able to foster citizens' trust in those branches. And from this, it follows that social rights adjudication offers us a means to essentially realize the value of trust to the citizen-government relationship. And that is, just to refer back, cooperation and all that follows on from that cooperation. The second justification that I put forward for a trust-based framework is I describe as theoretical. In a growing body of literature that's been kind of referred to as fiduciary political theory, scholars like Evan Fox-Decent and Evan Whittle, they've argued that various political or public law relationships, including those between, for example, the political representatives in the people and administrative agencies in the people, they can be characterized as fiduciary. And if we apply this literature and its fundamental or principal argument to the relationship between citizens and the elected branches with respect to social rights, we can, I suggest, characterize that citizen-government relationship as fiduciary. Now, for today's purposes, I'm not going to go into that, but I do justify it in the book. But if we accept that characterization, that is of the citizen-government relationship as fiduciary, an important consequence follows on from it. Private fiduciary law scholars, including Matthew Harding and Tamar Frankel, they've argued that because fiduciary relationships have trust at their core, ultimately seeking to regulate relationships that are based on reasonable trust, the law that regulates fiduciary relationships, or fiduciary law, should center on trust in those relationships. And in particular, fiduciary law, according to these scholars, should aim to facilitate trust between fiduciaries and principals, enabling principals to effectively trust their fiduciaries. And so again, if we apply this private law argument, or this argument developed in the context of private law, to the social rights context, together with our characterization of the citizen-government relationship as fiduciary, social rights enforcement by courts should, I again contend, likewise center on the concept of trust, specifically trust in the citizen-government relationship. My third justification for a trust-based framework is a more practical one. Now, it's been frequently noted in the social rights literature that courts, when they're enforcing social rights, they have to avoid what's been called kind of two wrongs that exist along a spectrum. At one extreme, they shouldn't intervene in social rights matters to such an extent that they effectively usurp the policymaking role of the elected branches, and so effectively make resource allocation decisions themselves. And at the other extreme, they shouldn't abdicate their role as protector of constitutional rights in constitutional democracies. So this would be, for example, if they were to defer too much to those branches. So because of this, courts are said that what they should be doing is they should strike a middle ground between those two wrongs, between judicial usurpation and judicial abdication. Now, significant for the trust-based framework that I'm proposing, the three expectations that constitute trust, goodwill, competence, and fiduciary responsibility, they have what I describe as a procedural orientation. Their focus is on procedure, and more precisely, the procedure that's followed by the trustee in their interaction with the trustor. So that is, just to kind of make it clear, whether the trustee has exercised goodwill, whether the trustee has exercised competence, and whether they fulfilled their fiduciary responsibility to the trustor. So to put it in kind of the simplest of terms, trust doesn't focus on the outcome of the interaction between the trustor and the trustee. And so applied back to the social rights context, trust in the citizen-government relationship, it necessarily follows, focuses on the procedure followed by the elected branches in making resource allocation decisions, rather than the outcome of that allocation. And because of this procedural orientation, a trust-based framework for social rights enforcement, what it does is it pushes courts towards procedural review. And owing to this fact, a trust-based framework, much like some other procedural approaches to social rights enforcement, what it does, I suggest, is it avoids those two wrongs of judicial usurpation and judicial abdication, and providing us with a good middle ground between those two wrongs of enforcement. So on the one hand, given trust focus on procedure, under a trust-based framework, courts don't make resource allocation decisions themselves, but at the same time, by reviewing the procedure followed by the elected branches in making resource allocation decisions, they still have, I think, a meaningful role to play in protecting social rights. So not abdicating their constitutional role. And then lastly, I advance a democratic justification for a trust-based framework. So a traditional defense for constitutional review that's been made, for example, by David Feldman and John Hart-Elliott, is that while constitutional review may be considered anti-majoritarian, it's not necessarily anti-democratic. And so here the idea is that courts, by way of constitutional review, can still support democracy. And this specific argument has been used in the social rights context by, for example, Sandra Fredman and Roz Dixon, to argue that to the extent that social rights enforcement supports democracy, it is justifiable. A trust-based framework, I claim, is compatible with this overall defense for constitutional review. And this is because public trust in government is itself good for or supportive of democracy. So democratic theorist Mark Warren, for example, he's argued that public trust in government is good for democracy because owing back to that link between trust and cooperation, public trust in government dramatically increases people's collective capabilities. And so it expands domains of collective self-rule. And by doing so, it supports democracy. Now, that being said, this conclusion, that is that public trust in government is good for democracy, is subject to a very significant qualification. Not all public trust in government is going to be good for democracy. So, for example, blind trust that would support authoritarian regimes, we can all, I hope, agree, is not good for democracy.
Yeah.
Warren has therefore argued that for trust to be good for democracy, it has to satisfy two conditions. First, it has to be what he's termed warranted trust. And related to this, Honora O'Neill has referred to in her work to the idea of intelligent trust. And second, it has to be justifiable to those who are affected by the trusting relationship. And these two conditions I demonstrate in the book, they can be accommodated or satisfied under a trust-based social rights enforcement framework, thereby permitting the trust that results from the framework to be good for democracy. And so because this form of public trust in government is good for democracy, a trust-based framework for social rights enforcement, which, as I suggested earlier, can foster public trust in government, or we can expect it to be able to do so, is by extension good for or supportive of democracy. And so lastly, and perhaps most pragmatically, very quickly, what does a trust-based social rights enforcement framework involve? Now, obviously, with the limitation of time, I can't go into it in too much detail, but I do deal with it at some length in the last 3 chapters of the book. And I explain that to promote trustworthiness of the elected branches, what the courts do or must do is hold the elected branches to a standard of trustworthiness. And they do that by enforcing those 3 constituent expectations of trust: goodwill, competence, and fiduciary responsibility. And so chapters 5, 6, and 7 of the book each focus respectively on one of those 3 constituent expectations of trust. What they do is they look at what does the expectation involve in the social rights context, and how can courts enforce that expectation. And then ultimately to illustrate kind of how the framework operates in practice and not to get too abstract, I try to use cases and constitutions from a wide range of jurisdictions to illustrate. So just very briefly, so in chapter 5, what I do is I focus on that first expectation, the expectation of goodwill. And I argue there that in the social rights context, it translates into 2 sub-expectations. The first being an expectation of procedural fairness, which would include elements of transparency, citizen participation or engagement, and respect for citizens' right to equality. And second, it encompasses an expectation of what I call good intentions. And that expectation of good intentions translates into an expectation that the elected branch's staff will not act, quote unquote, intransigently in making decisions about social rights related goods and services. And I claim ultimately that courts can enforce that expectation of goodwill by demanding a fair decision-making procedure from the elected branches. And that includes one, obviously, that is transparent, participatory, and respectful of citizens' right to equality. And by responding to instances of government intransigence by escalating to, shall we say, progressively less trusting judicial interventions. Then chapter 6, I turn to the expectation of competence. I argue that it reflects in the social rights context an expectation of evidence-based policy making, such that the elected branches make their decisions about social rights related goods and services based on the best available evidence. And similar to chapter 5, what I do is I propose that courts enforce that expectation by requiring the elected branches to provide evidence that demonstrates that their decision-making about these goods and services is in fact evidence-based. And then lastly, in chapter 7, I consider the expectation of fiduciary responsibility. And so in particular, using or integrating kind of the scholarship on private fiduciary law with the fiduciary political theory literature, I define this expectation as an expectation that the elected branches will fulfill their fiduciary duty of loyalty specifically. And more precisely what I do, and perhaps somewhat controversially, I argue that this expectation effectively translates into an expectation of non-corruption from the elected branch's staff. And I argue that to enforce this expectation of fiduciary responsibility, what courts should be doing is they should aim to curb corrupt practices from the elected branch's staff by taking a number of steps. And those steps include greater probing into the state's financial resources when they're claiming that they can't fulfill social rights obligations owing to limited financial resources. Second, strictly enforcing public procurement law. Third, holding non-state actors accountable to the public. Fourth, involving specialized anti-corruption agencies. And fifth, imposing financial sanctions on government actors. And again, I use illustrations from various cases globally to illustrate how that could play out in practice. And yeah, so that's the book in a nutshell. Thanks very much, and look forward to the discussion.
Thank you very much. So shall we go to Colm first then? Great, thank you. So Colm O'Connor.
Great, thank you very much, Jeff, and thank you to David for writing such a fantastic book and for such an excellent presentation today. I should say that I was the one of two examiners for David's PhD thesis that gave birth to this book. So, and what happened was really interesting, because when myself and my co-examiner got to grips with David's thesis, we thought it was absolutely fascinating, really, really interesting, theoretically and conceptually groundbreaking, a whole new look at social rights adjudication. Really brought David's background as someone with an undergraduate degree in psychology from Toronto into the picture, and you don't see that much psychology in law fusion. So we were absolutely fascinated by it, a bit too fascinated for David's well-being, because we battered away at him in a room in the LSE, I recall, for something like 3 hours. We lost track of time, so I think we may have subjected him to some questionable inhuman and degrading treatment for 3 hours. It was this time of year, maybe in February, I remember it. It was light outside when we started and it was dark when we finished. So I owe David an apology, I have to say, and I hope he doesn't start having a flashback hearing me commenting on this book. But the book is really, really excellent. I think, as I've said, its strengths are bringing this deep knowledge of psychology into debate and into dialogue with big branches of the legal literature that have historically not been that concerned with psychology. I think it's a tremendously interesting fusion. I should say I'm currently involved in a project looking at the constitutional legacy of the Weimar Republic's constitution, and it's very interesting if you go back to a lot of the German theoretical writing in the 1920s and 30s, people like Hermann Heller and others, who emphasized the fundamental importance of legitimacy to the stability of any constitutional order, and how legitimacy had to be constructed by legal, political, constitutional processes. It seems to me there's very interesting overlaps here with David's focus on building trust, the idea of trust being closely bound up with legitimacy. And you mention Mark Warren's work on democracy in that respect. I think this book makes a very, very valuable contribution to that broader school of constitutional public law analysis that looks at how legal mechanisms can build legitimacy, with trust perhaps being a facet of that legitimacy. And I think the book is fabulously well written, as I looked up, as we commented in our initial Viva report 4 or 5 years ago, and incredibly readable, extremely scholarly. So it comes highly recommended, and it seems to have not been too messed up by his Viva. I have a couple of points which I'll put on the table to sort of open up the discussion. First set of comments relate to relate to the issue of potential problems of relying on socioeconomic rights, social rights adjudication to build up trust. So assuming the general correctness of your framework, I just want to put on the table certain concerns that might be there about the way that socioeconomic rights, social rights jurisprudence might have a negative impact, because you set out a strong case as to why it could have a positive impact on trust. I want to maybe just very briefly flip up a potential set of potential downsides, how it might have a negative impact on trust. I then want to take a step back and sort of maybe question one or two aspects of the trust framework, and to probe a little bit about about the sufficiency of trust as a framework, and the sort of psychological assumptions that might underpin it. Okay. Just very briefly, my first set of points about the potential impact of social rights adjudication on trust. David's book sets out a very strong case for why and how social rights adjudication could reinforce trust. I think it might be possible to flip that argument and identify a number of areas in which social rights adjudication might undermine or challenge or threaten public trust if done badly, or maybe not even if done badly, if done in a particular way. There's a risk of false promises. Courts are going to protect your housing rights. Oh no, they're not. The group bone case from South Africa, the houses never got delivered. The risk of false promise. And I think this is a big issue for social rights adjudication. You're giving courts a sort of broad mandate to protect important social goods with big questions about their competency and capability. So is there a risk of false promising? Does it have an impact on trust? There's a potential issue of overreach. If courts start delving deep into housing, welfare, healthcare, entitlement, and so on, even if it's only process review, as you emphasize, is there a danger that they take on too much, that they have mixed consequences, that they don't get things right when they discuss issues of resource allocation? What happens politically if their decision-making ends up favoring less popular groups within society who might be, from a normative point of view, entirely deserving of additional judicial protection, but in practice, the outcome of that litigation leads to a perception that less favored groups are benefiting disproportionately from the process? Does that undermine trust? There's also the issue, you mentioned Honora O'Neill's work. Honora has often argued for trust as a reason for leaving other social processes to work reasonably untrammeled. You should trust other, I'm simplifying massively here, but trust other processes within society to do their job. And we should adopt this attitude of trust towards each other. So does that approach to trust, and you cite on Onor's work, does that translation, could that be read as arguing for a sort of judicial laissez-faire approach to other institutions? Just a set of questions there, assuming the correctness of the trust framework, raising some issues about it. On to my second set of points, which is sort of putting a question mark beside the trust framework. I mean, as you know, Tim Endicott has argued that actually, while it's true that lots of public bodies and public officials may owe fiduciary duties towards citizens and those they impact on, that public representatives, probably simplifying again here, don't really owe that sort of obligations to citizens. Instead, they sort of represent the general public. They represent the public good. They personify the people at large. And so they don't, in a sense, owe, I'm simplifying here, but owe fiduciary duties to anyone. Instead, they sort of embody the public. And does that suggest then that your fiduciary approach to trust maybe has a problem when it comes to that wider role of legislators in particular? And is there a danger of trying to stretch the trust framework to include every aspect of the democratic process as distinct from particular public authorities, maybe the executive and so on? And my final point, this has to reflect the inevitable political events in recent years, US election results from a few weeks ago. Again, putting a question mark beside the trust framework. You do assume that trust is built up by rational decision making, that the public likes rational decision making, that it likes orderly decision making, that sort of fits rule of law norms, that it's competent and so on. Now, you could argue that the general public shows signs of not placing that much value in that sort of decision making, that it wants other things. It wants excitement, it wants smashing up, it wants fundamental change, it wants transformation, it wants its anger reflected. You know, I've even seen a few people arguing that the Freudian death drive is the psychological framework that needs to be reintroduced into constitutional law. So I suppose my question is there a danger that the trust framework you're adopting only is a sort of partial reflection of the psychological needs and drives and views of citizens in democratic societies? And is there a danger of building too much on that sort of partial psychological framework, but there may have other needs, other drives, other instincts, which need to be addressed in constitutions more generally? Just a few thoughts, just to throw out on the table.
Terrific. Thank you, Colm. And as you know, David, you'll be given time, of course, to respond to both commentators for everyone's benefit. Over to Virginia.
Great. Thanks very much for inviting me, Erin and Jeff, and congratulations, David. That's a great book, and I'm very glad I had the opportunity to read. I was commentator on David's work in 2019. He reminded me it was in 2019 when he was early career. When he was in an early career workshop at LSE, and I was one of the commentators there. And it's fantastic to see what how you developed the project. Well, it was interesting because when I started reading it, I started thinking these are the same reactions I had back then. So I started thinking about my identity, about our brains. I don't know, but then it all down to because you have taken this forward in very exciting directions, and I have different comments to what I had. I didn't look for the comments that I had then. It would be fun to look at it at some point. But anyway, so congratulations, and that's a great book. My comments are the opposite to Colm, so it sounds like you may have found the middle ground. I will not repeat what the book says because David did it beautifully. There were a lot of things that I liked about the book. First of all, I really enjoyed that he's working on social rights. The last, 20 years, a few people, including my wonderful colleagues here, Jeff and Colm, have been working on social rights, but I'd say that lately there's less work being done on social rights, so it's fantastic to see such a great monograph on the topic. And such a bold and great effort to move the debate forward. The book makes a contribution to two rich bodies of literature, one on social rights, of course, but also on trust, and that is a great achievement. I love, as Colm said, the interdisciplinarity of the project and how they engages with several different strands of literature and makes it so it enriches the project hugely. The range of jurisdictions examined, as Jeff mentioned, such as the UK, South Africa, Canada, and other countries. And the book, as you heard, develops a trust-based framework as a foundation for legitimacy of judicial adjudication in social rights cases. And the argument is rich, as I said, carefully developed. It considers a lot of literature this far, addresses objections throughout. It's very carefully and nicely done. My objection, let's say, my question to David is, in the book, he insists on the procedural requirement. He says it has to be a procedural, we need a fair procedure for citizens to have trust towards the government. And he explains what he means about in relation to procedure, what procedural requirements there should be in judicial decision-making, what procedural requirements the courts should impose on the other branches of government when discussing social rights issues. But I've been thinking that if there is no substantive requirement there, then, citizens who are always disadvantaged and excluded and they take a social rights case to court, will not trust, they will also lose trust in courts if they take cases to courts, and they also lose in judicial decision-making. Of course, David says early in the book, and today he said that it's a procedural requirement, not substantive. But there are these great pages in the middle of the book, about page 133 onwards, I think, where he includes very significant substantive requirements in the framework. He talks about equality and how equality is important for citizens to feel, for trust to be promoted in judicial adjudication. And not only does he talk about formal equality, but he says that the right kind of equality here is social equality, substantive equality, including social equality. So this made me think then, the courts have to protect some basic social rights for citizens to feel trust. It's not just a procedural requirement I felt there, and I may have misunderstood the way you're thinking about it, or it may be that you're doing that we're agreeing that a procedural requirement in judicial adjudication, the procedural requirements as you develop them are great and interesting and exciting, and they would certainly promote trust, and I liked a lot of the points that you made. But there is a substantive requirement there as well in your framework, a requirement to promote social equality, without which we will not, citizens will not trust the courts, will lose trust towards the courts and towards the government. And I'm thinking the other branches of the government, and I'm thinking about specific cases. A lot of we have a lot of legislation that has an appearance of legitimacy, but it excludes people who are most disadvantaged, such as the universal credit framework here in the UK. The poorest who really suffer, and they go to court and they lose. They have lost this far in some key cases. Will citizens not lose trust then to the judicial process, but also to the other two branches of government if they just lose in these cases, even if the court imposes some substantive, procedural requirements and follows your framework, but without a substantive equality ideal there or outcome for them. So this is my question, and I look forward to hearing your thoughts.
Thank you very much, Virginia. So, David, we've heard from two profound scholars on the topic of social rights, and I'll give you about 5 to 8 minutes if you'd like to respond, and then we'll open the floor for the last half hour.
Okay, well, thank you both. No, it's great to have both of you engaged so closely with the book. So I guess I'll deal with kind of the comments in turn. I can't do them justice, but In terms of, potential problems with kind of social rights adjudication. So I think so I guess it's to some extent this kind of teases out some of my kind of concerns with the way in which kind of legal scholars engage with the concept of trust. So I think one thing, I try to go to great lengths to kind of distinguish trust as this kind of, for lack of a better term, kind of this procedural idea, because oftentimes we talk about trust in a very kind of substantive way, which I don't actually agree with. And there's even confusion in the trust literature. So, for me, it doesn't make sense, and I justify it in the book, but it doesn't make sense to say, I trust you to do X. And so if you don't do X, then you've betrayed my trust, because there may be very good reasons for you not doing X. And so when we talk about, for example, when Virginia was saying in terms of, the courts not ultimately kind of protecting social rights from a substantive standpoint, or there's, to some extent, I think there's a bit of a kind of conflation and basically reverting back to kind of this idea that trust is substantive, and that therefore we'll lose trust if we don't get the outcome that we're seeking. And I think also there's, another element of trust that I try to go to great lengths to emphasize is the kind of the relational aspect. So very much the focus is on, we're not talking about trust broadly speaking, we're talking about trust in particular actors. And, my work is focusing specifically on citizens' trust in one particular, shall we say, set of actors, and that's what I call the elected branches. Now, as both of them have kind of pointed out, there is a concern, or there's also this trust relationship with the courts. And so I don't know whether or not I'm necessarily convinced that trust in the courts will be undermined by some of the things that have been kind of suggested. Again, depending on how we define trust and making sure that we think about trust in kind of a procedural in terms of those three expectations as opposed to kind of the outcome. But yeah, there's some of the thought that I had there. With respect to kind of the fiduciary problem, so this is something that comes up quite a lot. So so my work, I do rely on the fiduciary political theory literature and this idea that political relationships can be characterized as fiduciary. But unlike that literature, I'm using it for a very kind of, shall we say, specific purpose. And that is, so it's kind of the benefit, or I'm glad that it's quite an honor to kind of, everyone says nice things in terms of the interdisciplinarity of the work. But one of the struggles is, different disciplines use the terminology of fiduciary in different ways. And so one of the, the sociology literature has used the terminology of fiduciary, but they're not thinking of it in the way that we as lawyers would necessarily think of. So I rely on kind of the fiduciary political theory literature to kind of justify why I think this relationship can be considered fiduciary. But my real kind of purpose in trying to characterize it as such is to kind of tap into that sociology literature. So it's and so I'm using it for a very specific purpose. And as I kind of develop in chapter 7, ultimately, that's why I kind of get at that kind of expectation of non-corruption. So I think a lot of the concerns that have been raised by legal scholars around that characterization is because they're using it in a much more expansive way than I'm trying to use it. But also, they're also defining the fiduciary obligation in a much more expansive way to kind of as this kind of bundle of obligations that I'm not kind of proposing. Then so Colm's point about trust being rational. So and absolutely spot on. I agree. And I agree that trust, so that's part of the reason why I say, or try to be careful with my terminology or language to say that it should kind of promote trust. There's no guarantee if it's promoting trust, obviously, because people aren't rational. And it's also one of the reasons why we were actually just talking about this, but I focus on trustworthiness as opposed to trust. So a lot of people misunderstand what I'm trying to say and think that I'm, trying to say that we should, try to maximize trust as much as possible, and we should. And that's not the idea. The idea is that we should be trying to ensure that people can trust their government. And ultimately, if that leads to trust in government, that's great, because then we can reap the benefits of that trust. But there may be certain individuals, certain members of society that no matter what you do, in the sense of, you know, trustworthiness, they will not trust government. And so like that's and speaking to this point, there's been research done that in fact, so a lot of the literature on the empirical literature on trust that says trust leads to cooperation, which has all those kind of valuable benefits. It's actually not trust per se that leads to all those valuable benefits. It's trustworthiness as a kind of stepping stone to trust that then, so really we should be aiming for trustworthiness rather than trust per se. So if it doesn't lead to, you know, while kind of to some extent, I'm hoping that people are rational, not too much, I think, hang on that, I think.
Thank goodness for that.
Yeah. And then finally, just to Virginia's point about, so I try again to be, and it's of course, obviously an excellent point. I try to be careful in terms of using kind of, so I recognize, and I also say that it's kind of partially procedural as opposed to substantive, but so I rely quite heavily on the work of Sandy Fredman, who I think is excellent in this area. And so she kind of makes two, I think, very, very good points in this area. So one, she says that obviously we have to draw a distinction between what social rights protect, broadly speaking, and what courts are justifiably able to ultimately do when it comes to enforcing these rights. So social rights in a constitution will necessarily have meaning beyond what the courts can kind of provide. And so there will be obligations that stem from those constitutional obligations beyond what the courts can do. So so I kind of, you know, while I recognize that there may be, you know, rights to housing or rights to, in the sense that the state should be providing these things, it's not a justifiable kind of role for the courts when it comes to this area. And with respect to substantive equality, sorry, I think I went over 8 minutes, but the second point that Sandy Fredman makes, I think, is also an excellent point. She says, you know, while she justifies or she argues for a substantive equality approach, she takes, in terms of the role of courts when it comes to enforcing or kind of protecting, judicially protecting the right to equality, she kind of adopts a procedural almost standpoint where she says that what we should expect from the state or from, you know, courts is to basically demand what she calls a reasoned justification from government when they're making resource allocation decisions. So do they have a reasoned justification where, in particular, where their decisions have a particular impact on those who are kind of disadvantaged? And so I think her approach, which I, you know, kind of encapsulate and bring into my framework, because I think I agree with it entirely. It still kind of strikes that balance, in my view, between kind of the substantive role that some people would argue for the courts, but without kind of leading to judicial abdication.
Great. Did you want?
Very quick, yeah, so I noticed that passages, obviously, with Fredman and all that, and you know, Colm is worried about judicial overreach. I'm worried about judicial underreach, right? And Fredman says, and you say, I can't remember now, my notes are not that clear. The decision maker should show that their choice redresses disadvantage, but also promotes respect, dignity, accommodates diversity, and counters exclusion. So to me, that was very substantive. That was great, but not just procedural. That's all. Yeah, no, that's great. That's great. Well, thank you.
Excellent. Okay, perfect. So we'll open the floor. I'm going to take 3 questions at a time, and we won't have any shortage of them. Maybe we can encourage people to be somewhat succinct in their questions. I have some for you as well. I'll put myself number 10. I think I saw. Could you please announce yourself for those online as well? When you respond to the question, so everyone knows. If you can keep your hand in the air for a moment, I'll write down the order, and we'll start with Richard Bellamy. But if the rest can keep your hand in the air, please, just so I can mark everyone down.
Shall I start?
Yes, please. And if you speak clearly for the mic to pick it up, please. Thank you.
So I wonder if you put too much into the notion of trust in an analogous way to which someone like Raz says people put too much into the rule of law. So, I mean, one name, which I'm sure you know his work on trust, but you didn't name check him, is Diego Gambetta. And he gives, an account of the mafia as being there when there's an absence of trust. And their way of governing is, of course, to increase that absence of trust. But an authoritarian but consistent ruler like fascism is sufficient to overcome that problem. So that means that you then begin to put more substantive concepts into your account, even into your processes. They begin to sound a bit like democratic processes, even. So one question is, why don't democratic processes themselves, why aren't they sufficient? And can you overcome the overreach problem once you begin to get the courts involved? Like, for example, you gave an example at the where you sort of said they would check to see whether there really was money available for the social rights or not. So that would mean what? Challenging George Osborne's view that there was austerity and they had to do it, and would that not be a democratically controversial statement?
Okay, we're going to take two more questions. Kevin, you were next on my list.
Yeah, hi. So I don't think I fully understand the difference that you draw between a procedural idea and a substantive idea of trust. So my question is going to be like a common sense understanding of trust. So I'm still wondering on this point, that does it matter for your theory that courts themselves should be trustworthy, or that sometimes they are empirically trustworthy? I mean, people do repose trust on courts. Because I mean, this kind of public perception also, as an empirical matter, sometimes matters to courts, and a trustworthy or a trust-seeking court might not have the incentive to exercise trustworthiness, promoting judicial constraint, as you put it, and could even justify strong form judicial review by using the very language of trust and fiduciary duties. So even though your account is primarily with the elected branches, can't the same trust framework lead to different outcomes if applied between the citizens and the courts?
Thank you. And Oliver, if you could announce yourself for the benefit of those participating online.
Okay, thank you.
Yeah.
I'm Oliver Gerstenberg, member of the faculty. Thank you for your paper. I mean, you deployed a private law framework, which you said at the beginning, where individuals are in a fiduciary relationship to the state as clients of the state. But what was, in my view, missing is the idea of the Constitution and the idea of a civic republican process where we are not just clients of the state, but we are co-authors of the legal system under which we live. So for me to feel trust in somebody or in something or some decision making implies to have some kind of voice and some say. So that throws us back a bit like what Richard said to the very idea of a democratic process, a bit like as anticipated in Evie's argument about democracy discourse. So aren't we just caught in your framework that citizens are just seen as clients, and where is the Republican side where we can talk back to the state, where we can have a stake in it, and especially in the domain of social rights?
Thank you, Oliver. So we have three questions, mindful that we have another 7 on the list. Okay.
1 second.
Yeah, I think very quickly. So Richard, thanks for your point. I guess the best way I can kind of answer, but obviously there's much more to discuss, is it's almost, so I guess my starting point, it's kind of starts from kind of the way I started from the beginning, is this idea that because of the fact that these rights are constitutionalized and have been accepted as kind of justiciable, the courts have to do something. And so I'm trying to find a justifiable basis for, not justifiable basis, a justifiable role for the courts. And so I'm using the concept of trust as kind of the foundation for that role. In terms of whether or not, the limitations of kind of the democratic process, I guess I'm not actually speaking to that. I guess to some extent, if we could, through the democratic process, trust and there was trustworthiness through alternative means, and I recognize in the book that, you know, courts are just one part of the larger mechanism, and so that's why I don't want to. I'm concerned about kind of not so much judicial overreach, but also just kind of judges doing what they're not in the best position to do. So I guess that's the best way I can answer the question in terms of the starting point that I'm kind of looking at. In terms of the idea about kind of trust in the courts, and so, you know, one of the chapters in the book that I didn't even touch upon in the presentation, I think it's chapter 3, is I try to kind of problematize this relationship that I'm focusing on and recognizing that there's multiple trust relationships as part of this kind of what I call the network. And they're all kind of in kind of relationship with one another, and they're all, so one of those relationships that you pointed out is, which is absolutely true, is the relationship between citizens and courts. And to some extent, and I also address this in the book, that, you know, my framework kind of assumes trust in the courts, because, you know, a lot of things that I'm kind of advocating, I'm kind of hoping or assuming that people will trust the courts. Now, to justify that assumption, one, the literature kind of consistently shows that of the political branch, or sorry, of the branches of state or branches of government, the courts are generally the most trusted. So I think there's some foundation for kind of expecting that people do have trust in the courts. But I also kind of, it might sound like a bit of a cop-out, but I think that if we don't have trust in the courts, it's kind of a bigger problem. And because any social rights enforcement framework assumes trust in the courts. So regardless of kind of what kind of framework we use, as a starting point, we need to have some trust in the courts. Otherwise, everything kind of breaks down in the sense of, so it basically we have to go back to first principles and kind of deal with that trust before we can kind of talk about anything else. So to Oliver's point about kind of voice, I agree. And so part of what, you know, in terms of my procedural fairness, so that under the goodwill, I think it's very important that and part of what I'm trying to do is to get, you know, the citizen involved. So some of the things that I include in kind of the trust and, you know, rooted in the trust literature is the idea first of transparency, so that the public knows what's going on and can kind of hold their elected branches to account, but also that the relevant resource allocation decisions be participatory, so that those who are impacted by the decisions have a voice, have a say. And voice is interesting that you use the terminology of voice, because voice has been recognized as fundamental to trust, that people do not trust a relevant actor if they don't have a voice in the decision making being made by that actor. Hope that answers.
Great, thank you. So for the next 3, I'd ask Natalie, I think you had your hand up, and again, announce yourself today.
Yeah, I'm Natalie Sadaka. I'm at Durham. Yeah, thank you. This is really interesting. I was going to go a bit more into that question on substantive as well. I know you have lots of different reasons for the emphasis on procedural rights, but one of the things you mentioned is this kind of, yeah, like Octavio Ferrer's work on the on the health rights litigation, and how that sort of just ends up benefiting, increasing inequality and benefiting wealthier people. And I guess, you know, there's various potential responses to that, like the more straightforward one in a way is like that you need a better system of play, like a more vibrant NGO sector that would allow a greater range of people. But it also occurred to me that, like, because you also argue for judges, that judges could become better at adjudicating these issues in certain ways, right? So in a way that could also address some of the problems that you see there, that you might not just say, well, someone's come before me wanting an expensive drug, and so it'll be granted. You might become better at balancing things out. So yeah, I know that there's other reasons that you would focus on the procedural, but I wonder if that just affects that question of substantive rights a bit.
Okay, and then Erin.
So I do think that you have a terrific project, but there's a operationalization issue, right? So you assume that the government at hand is going to want to comply. And that does a lot of work for you, because obviously as soon as a court says and heightens and says you're untrustworthy, trust collapses. And you don't actually have a theory of rebuilding that trust. And so in that story, right, the trust collapses, and then your theory, I think, just ends up being a political process theory, which is great, and I love it. But I think the trust element sort of drops out. And so I think two thoughts that develop from that. One is the substance bits might actually need to stay in order to avoid kind of the reductio to just another process theory, but to do something a little bit more to then start the conceptualization of rebuilding trust if this actually comes to fruition. But then second, and my sort of more interested question from my perspective, because I'm interested in institutions, is can you assume that governments are going to want to comply? And you said there was a little bit of a cop-out in your earlier answer about courts when you said, well, we should trust courts, but that doesn't mean trust them to do this particular job, right? Trust them to do social rights adjudication. And so then my question for you is, could you think about, maybe as a next project, what kind of political systems would be best suited to this? So a parliamentary system with first past the post elections would strike me as not particularly well suited to this, because why would that government need the court to build trust when it has a relationship with the electorate? But maybe in other kinds of systems, divided government in a presidential system, a system of proportional representation, you could envision the political branches needing the court to operationalize trust in a way that might not be true in every political system.
Great. Thank you, Aaron. So, Eduardo.
Yes.
Yeah.
Oh, hi. My name is Edward. I'm PhD candidate here, and I'm going to read your book for sure because I'm also working on the role of court. So I really have thousands of questions, but I'm going to focus only on two. The first one, is there room within your framework to argue for, so it's clear that your priority is in the procedural obligation that would be required. Virginia mentioned a degree of space for some substantive considerations as quality, but I'm wondering right now, beyond that, on litigation based on goals, and I'm thinking specifically on the climate change cases. I'm thinking Urgenda in the Netherlands, where you have now a judgment that says that the state has to do basically whatever it takes to make it to the Paris Accords objectives of reducing 1.5 and its established percentages and everything. It is arguable that may have been an overhaul to some extent, but I wonder if, but still there seems to be a building consensus in climate change law that we should all be doing at least something towards achieving those objectives. So I was wondering if it's possible to articulate these types of challenges, legal challenges, with your framework. And the second one, shorter, it's what happens in cases that there is like discussion on what the correct science is. And I'm thinking, for instance, Bolsonaro in Brazil, who argued that COVID-19 vaccines, I don't know what exactly was his belief, that they weren't any good. And there were some people arguing that was the scientifically correct position. And I was wondering if science becomes has a role in this determination. What happens if there is either conflicting science or there's a little bit of cherry picking on the science on which one they're going to use. And that's it. Thank you.
Great, so that's our next three questions. We'll hand over to you. We have about another 4 or 5 coming after, so bear that in mind.
Okay, so yeah, I guess just very quickly, thank you all. Yeah, so to Natalie's point about kind of Faraz's work, and yeah, so I think to some extent, I think I see your point in the sense of the kind of by improving the role of courts, but I still think there are serious kind of reasons for why the courts shouldn't be making kind of those types of more substantive decisions. So I think Faraz makes very good kind of arguments as to, you know, the ramifications of it and how it could ultimately play out. But I still think that there are concerns around kind of going to those points of legitimacy and competence and capacity that were the reason why for 20 years before the last, or more than 20 years, there's been concerns around whether or not these rights should be justiciable at all. So I think we can't necessarily kind of wipe those out. So I think there are additional reasons for why I wouldn't be on board with a fully kind of substantive approach. Aaron's point, so I thank you. I think there's a lot there, and I obviously want to adjust this, but so in terms of assuming compliance, so I don't think one thing that I had to kind of include, and I have included in kind of the framework, is so I draw on the work of John Braithwaite in the regulatory pyramids, and I think that does do a lot of does address a lot of the concerns around kind of governments and whether or not they'll want to comply, in the sense of I think that the courts can, and South African courts have recently done this in social rights cases, is kind of signal very clearly to the elected branches that they will escalate with what I call less trusting kind of interventions. So I'm not necessarily assuming that there will be this desire to comply. But again, it's kind of, and it may be that ultimately the government won't comply. And I think, again, it's then again, regardless of what framework we ultimately introduce, like I think I'm always going back to Richard in the sense, my starting point is kind of I'm trying to figure out, well, what role can we justifiably give to the courts when it comes to these rights that makes sense. There may be in it, and your question about
if they comply after being told they're untrustworthy, does that make them trustworthy? So I assume compliance in the end, but there's a distinction between compliance at stage 1 and then the heightened. Then isn't the court saying you're untrustworthy?
They're told off and then they comply. Then they, the trust has broken down before that. So you ended up in court challenging the legislation.
Well, so that makes sense. I guess to that 2 points. One is that I think kind of there wouldn't be kind of the label of you are untrustworthy. It's kind of they're focusing on the elements that would speak to trustworthiness, but I don't think that the court's role would necessarily be to say kind of label, say you government are untrustworthy. To speak to the point about kind of if they don't comply, and I say this kind of in the book, is that at some point trust and trustworthiness kind of has to take a second back seat, in the sense that to get them to comply. But I also think that because of the, shall we say, prospective nature of trust and trustworthiness, by setting that kind of message right now, I don't think it undermines trustworthiness. You're right, it undermines trust. But with the ultimate goal of building trustworthiness, because it's sending a message to future governments that you have to comply. And so that compliance, that basically they're moderating the relationship between the public and the state in a way that, and that goes back to my point about the goal shouldn't be trust. If trust comes about, great, because we want that, but the real goal should be trustworthiness. And so I don't think that it necessarily undermines the trustworthiness, if that makes sense. But I have to give you more
Whether or
thoughts.
not it does, let's go on to
Sorry. And just sorry, thanks to Edward. So goals I haven't given much thought to, so I have to give that more thought. And with respect to the correct science, so I with respect to kind of evidence-based decision-making. So I argue in chapter, I think it's 6, for a limited role, in the sense that the court's role should be to determine, to make sure that it is evidence-based. So they would have to kind of look for whether or not there's, similar to private law, whether there would be kind of a respectable body of science that they should themselves be engaging in the evidence-based decision-making process, so that they say, oh, you chose that science, but we prefer this science. But provided there's a respectable body of, shall we say, medical opinion or scientific opinion, and so the court's similar to what they do in other areas, I think they can do that in this area.
Okay, good. I think that in light of the time, I'm going to invite all of the remaining persons who have questions to state them, and to state them as briefly as they can. And I'm going to put 2 that have been posed online. The first is from Gaurav Mukherjee, who's also done interesting work on social rights. He asks whether your idea of trust is concerned primarily with vertical trust between citizens and their elected representatives, and whether ideas of horizontal, i.e. between branches, and diagonal, between branches and guarantor institutions, also figure in your analysis. Okay, so that is the question, not just vertical, but horizontal and diagonal figure. Now that is from Gaurav. The second is from, and I'm abridging some of these, pardon me if I do it too much, from Miriam Hunter-Hennen, a colleague at UCL Laws who couldn't attend in person today, but has been watching. She wonders whether your underlying assumption that social rights are inherently more problematic to adjudicate than political rights might need revisiting. In her work on freedom of religion, she discovers that the ease of adjudication of political rights is only a myth, repeatedly. So in addition to those 2, I'll put one question to you. Well, one worry is that could administrative law do the work? But my main question is your concept of truster, the trustee is the state, the truster is the person, is either the recipient of the benefits or the electorate more broadly. I wondered whether you have too homogeneous a conception of truster, whether you need to account for a heterogeneity. I think this underlines what Colm was getting at. You have people who don't like other people in the truster category. And the people that are objecting, who will judge the trustee's behavior, are fundamentally disagreeing with each other, but they're both under the umbrella of truster. That is, the recipient of the benefits and the taxpayer who doesn't want those benefits to go there. We have to hear from Berihun Olga, and I think that's it, actually. Or, okay, yes, okay, sorry, okay. So let's start, Olga.
With the visual source, my question was about the rights-based framework in liberal democracies, and generally speaking, that is the notion of political regime. They're framing it differently, the state of civil and political rights, which is into this equation, because what I witnessed myself, and I didn't feel probably watch it, and I was interviewing people about the knowledge of rights, and they always used to respond, yes, absolutely, right to work, right to rest, right to reward for Russia and Belarus. It's been on the news, are currently launching a cooperation in the field of human rights that has been announced a couple of days ago with social and economic rights being at the sort of the front. And this is what's happening in Hungary, when social and economic rights are sort of approached for discourse. So the question is, provided that the liberal democracies are appropriating the notion of social and economic rights and using them as a sort of placeholder for civil and political rights that are being pushed back, the question is that either the state of civil and political rights fits into this model, how does, and this is a variation of Miriam's question, or that does the political model feature into this equation? Is this one of the variables in this model?
Okay, thank you, Olga. Berihun.
Okay, so it looks to me that your idea of trust puts a lot of pressure on courts. It gives an additional role to play in the constitutional system, but that's not for the sake of social rights, right? Now, courts has to do with the rule of law. courts may have to do with, democracy, either protecting or safeguarding it. Now they have to do something with trust building, whatever that is. So here, I would like to hear, your views about the proper role of the judiciary in a constitutional system. And it looks like you are working at that broader level. But related to social rights, actually the law may be sufficient in some circumstances. For example, in global South constitutions, they can't do much related to social rights enforcement if they simply have, the right view of, the law of social rights. They can't have international human rights law, which imposes duties on courts and the political branches. And if they have some understanding, they could do something there. And even within constitutional law, they have duties actually to, as Virginia said, to do something substantive. And here, the debates, both in South Africa and even India, is not whether, the proper role of courts to do this, to do that, but the entire idea of whether the constitutional system they have is sufficient for their conditions. And Tina Rocks wrote an important piece where, Kate Oregon and others, have made important interventions. So I think if you see your contribution from global South constitutions, it looks like it's not doing much for social rights, doing a lot for courts, but not for social rights.
Okay, thank you. I'm afraid we're going to take one last question from Anna, and then maybe after we wrap up, because we're right at the end of our time. So we'll have one from Anna, and then we'll have a rapid fire response as best you can do.
So pardon me if it's brief, David, but you can give a very brief answer. It's simple. I'm just not sure I understand yet the relationship between trust and trustworthiness for you. It's been touched on a few times, and you seem to emphasize what you're interested in is trustworthiness, not trust per se. The chapter focuses on instrumental, and I would think what I would also label as kind of intrinsic benefits of trust per se. And I can see what those are. I can see how it would be a good thing if that trust obtained either between people or in a polity. But of course, you don't need actual trustworthiness for trust. You just need perceived trustworthiness, right? That's not sort of what gets you trust. There's a benefit also in either an individual or a political institution being actually trustworthy, such that that means they are meeting certain kind of independently valuable standards of behavior. They're being honest, they're being diligent, they're responding in the right way or with the right disposition and with the right interest to the moral demands of others in the role that they have. Great, but why does that benefit, like the benefit of trustworthiness as opposed to trust, kind of cash out vis-a-vis trust, if that makes sense? It seems like that's just a thing that we want people to do. Those are virtues we want people to have, or those are things that we want courts to sort of do when they adjudicate. But why value that in terms of trust, I suppose? So I can see the value of trust and I can see the value of trustworthiness, but the value of trustworthiness doesn't seem like it's necessarily connected to the value of trust.
Thank you, Anna. Now, we are at the end of our time, so I like to hear from David personally, but if anyone needs to leave to be off to something, they absolutely shouldn't feel apologetic for doing that. So you can do so. David, if you could wrap up in the next few minutes.
Yeah, of course.
That would be good. Thank you.
Yeah, thanks again. So just very, very briefly, so to Gora's point about kind of vertical, horizontal. So yeah, obviously, I've tried to convince people my fascination with trust. And so there's a lot of, and my work continues on trust. So my work does focus on kind of vertical trust, this relationship between kind of the individual and specifically the elected branches. So there's also the trust of the courts, and there's also, horizontal trust, not only between the trust of, institutions with each other, kind of the trust of institutions in one another, but also I think as a number of the questions I've kind of teased out, people's trust in each other. So which has been termed in the literature as social trust. So I briefly touch upon it in the book in chapter 3, but it's not something that I can go into in much detail. And so all I can say is that it's kind of, I'm hoping to do it in future work, because it is something that I think has a lot of relevance and I find personally very interesting. I'm going to deal with Miriam's and Olga's questions together. So I think another way to kind of frame your questions is kind of why doesn't my framework apply to civil and political rights? And I've received that question a lot, and it's a great question. I touch upon it in the conclusion just to say, I do think there is applicability beyond social rights, and the best way I can kind of explain is that I went in to the PhD with an interest in social rights, having read, work by people like Jeff and others, and trust just kind of was my way in. And in terms of like that, I was interested in kind of that relationship, but I do think that trust has broader kind of relevance beyond obviously social rights. The only caveat is obviously a lot of the things that I developed, including in the chapter that was circulated, I've developed in the context of social rights, so they would need to be kind of adapted and tweaked depending on civil and political rights, but I think that there is definitely relevance beyond that. To Jeff's point, I have to give that more thought in the sense of the homogeneity, but I do think that there's a difference though between trust and, again, going to that distinction between trust and trustworthiness. And so trustworthiness, when you flip it on its head, deals with, I think, a lot of the concerns around that homogeneity, but I have to give that more thought. To Berwin's point, which is a lot there, thank you. One thing I will say is, so into that idea of courts as kind of trust builders. So there's multiple ways in which you can look at my theory or my framework. So one way that I've developed is to use trust as the basis for arguing for a framework. Another way that I think you can look at it is there's a lot of existing work on social rights that argues for participation, transparency, equality. So I'm kind of justifying those things in terms of trust. So it's not necessarily that I'm saying that courts have a role and should be, their obligation is to build trust. It's that trust kind of provides us yet another justification for some of these things that existing kind of work and scholars have advocated. And I just think that trust kind of brings it all together into one neat, concise kind of framework. And to Anna's point, the only thing I can kind of very briefly say on that is the relationship. So trustworthiness, as I define, is kind of the likelihood of, or the probability of trust being fulfilled. And so the relationship with the distinction there in terms of value is that distinction that I mentioned briefly in terms of warranted or intelligent trust. So obviously, so trustworthiness, basically the trust that would come out of trustworthiness would be warranted trust. It wouldn't be kind of the blind trust or other kinds of trust. The distinction that you drew there between kind of perceived trustworthiness is a very, very good one that I'd have to give more thought to, but I think it's something.
Terrific. Can everyone join me in thanking our